All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and court practice for immersion. The oak doors of Atlas Hall Courthouse stood closed against the late afternoon sun as Judge Keystone prepared to reconvene the suppression hearing in Granite County versus Rook. Inside Courtroom 4, the air felt dense with anticipation, heavy with the unspoken tension that comes when sworn testimony collides with recorded evidence. Defense Attorney North stood at the podium, a manila folder open before him, his posture relaxed but his gaze sharp and unforgiving. At the witness stand sat Deputy Holloway of the Harbor Police Department, uniform crisp and pressed, but his face pale and strained, beads of sweat visible on his forehead despite the courthouse air conditioning. Prosecutor Slate shifted uncomfortably in his chair at the state's table, jaw tight, sensing that the routine motion hearing he had expected, a simple defense challenge to a consent search, easily defeated with the officer's testimony and body camera footage, was about to veer into dangerous and unpredictable territory. Judge Keystone, a 15-year veteran of the bench known throughout Granite County for his meticulous attention to procedure and his unyielding intolerance for evasion or half-truths, watched the exchange with narrowed eyes, his pen tapping rhythmically against his legal pad in a pattern that the courtroom regulars recognized as a sign of mounting impatience. The gallery, packed with reporters from the local paper, law students from the state university, and curious locals who had heard whispers that something unusual was unfolding, leaned forward collectively, breath held as North prepared to ask the question that would shatter the state's case and redefine the boundaries of acceptable police testimony in Granite County. This was supposed to be a simple suppression hearing, defense challenging a consent search, state defending the officer's account, judge ruling on the motion, and moving on to the next case. But the body camera footage played moments earlier had revealed a troubling and undeniable discrepancy between what Deputy Holloway had written in his arrest report 4 months ago and what actually happened on the dark shoulder of Route 9 on that Tuesday night. Now North was circling back to that discrepancy with the surgical precision of a lawyer who knows he has the evidence, knows he has the law, and knows the judge is watching every move. Judge Keystone's patience, already tested by 2 prior warnings about non-responsive answers and evasive testimony, was running dangerously thin, and everyone in the room could feel the pressure building like a storm about to break. The collision between sworn testimony and recorded evidence was about to ignite, and the fallout would reach far beyond this single case, touching careers, reputations, policies, and the fundamental question of whether the criminal justice system can hold itself accountable when one of its own crosses the line. Before we dive deeper into the storm that's about to break loose in Courtroom 4, take a moment to subscribe and comment below on what you think happens when a cop's story doesn't match the tape, because what unfolds next will shake the courthouse to its foundation and redefine how every lawyer, judge, and officer in Granite County approaches their duty to tell the truth, the whole truth, and nothing but the truth. The charge against defendant Rook was possession with intent to distribute, a serious felony carrying a potential sentence of 5 to 15 years in state prison, stemming from a traffic stop on Route 9 just outside the Riverbend city limits 4 months earlier. Deputy Holloway's arrest report, filed with the Harbor Police Department and entered into the record as the foundation for the charges, stated that he had pulled Rook over for a broken right taillight at approximately 10:15 p.m. on a Tuesday night in late summer. According to the report, Rook exhibited nervous behavior during the stop, trembling hands, rapid speech, darting eyes, and when Holloway asked if there was anything illegal in the vehicle, Rook allegedly gave verbal consent to search, saying, "Go ahead," or words to that effect. The search, Holloway wrote in careful, precise prose, uncovered a small quantity of controlled substances in a hidden compartment beneath the rear seat, wrapped in plastic and concealed under a floor mat. Rook was arrested on the spot, handcuffed, read his rights and transported to the Granite County jail, where he was processed, photographed, and held pending arraignment. The case moved through the system with the predictable rhythm of most drug cases. Arraignment, where Rook pleaded not guilty, discovery requests filed by Defense Attorney North demanding all police reports and video evidence, a denied continuance motion when North argued he needed more time to investigate the circumstances of the stop, and finally a pre-trial hearing scheduled to address North's motion to suppress the evidence seized during the search. North's argument, laid out in a detailed brief citing Fourth Amendment case law and state constitutional protections, was straightforward and compelling. The stop was pretextual, initiated on a fabricated pretext to justify pulling over a vehicle that Holloway had no legitimate reason to stop. The consent was coerced, given under the implicit threat of arrest and the power imbalance inherent in any encounter between a lone driver and an armed police officer on a dark roadside, and the search exceeded any lawful scope that might be justified under the consent doctrine. Prosecutor Slate, in his opposition brief filed 2 weeks before the hearing, leaned heavily on established case law regarding traffic stops, consent searches, and the good faith exception to the exclusionary rule that allows evidence to be admitted even when officers make reasonable mistakes about the law. The hearing was set for a Tuesday afternoon before Judge Keystone, and both sides expected it to last no more than 90 minutes, perhaps 2 hours, if the cross-examination ran long. Slate was confident. He had the arrest report, the officer's testimony, and body camera footage that he believed would back up every element of the state's case. North was skeptical but meticulously prepared, having reviewed the footage frame by frame, noting timestamps, comparing audio to written reports, and identifying the precise moments where Holloway's account diverged from what the camera captured. What neither lawyer anticipated, what no one in the courthouse that day could have predicted, was that the hearing would unravel not just the search and the consent issue, but the credibility of the officer, the integrity of the prosecution's case, the patience of the judge, and ultimately the career of Deputy Holloway himself. The hearing began at 2 p.m. sharp, with Judge Keystone calling the case and both counsel announcing their appearances for the record. Prosecutor Slate, wearing his usual dark suit and conservative tie, rose and called Deputy Holloway as his sole witness, confident that the officer's testimony would hold under scrutiny and that the body camera footage would corroborate the key facts. Holloway took the stand, was sworn in by the court clerk with his right hand raised and his voice steady, and began his direct examination by recounting the stop in careful detail. He was on patrol, eastbound on Route 9, when he observed a vehicle ahead of him with what appeared to be a broken or malfunctioning right tail light. He initiated the stop, using his lights and siren. The vehicle pulled over onto the shoulder. He approached cautiously, as he had been trained, and made contact with the driver, later identified as Rook. He noticed immediately that Rook exhibited nervous demeanor, hands shaking on the steering wheel, eyes darting between the rearview mirror and the side mirror, voice unsteady when asked for license and registration. When asked by Prosecutor Slate if Rook consented to the search, Holloway testified clearly and without hesitation. Yes, he gave verbal consent. I asked if there was anything illegal in the car, and he said I could search. Slate asked if Rook had hesitated or refused at any point, and Holloway said no, that the consent was given freely and without coercion. Slate then introduced the body camera footage into evidence, and the courtroom fell silent as the monitor mounted on the wall above the jury box displayed the stop in real time, the grainy nighttime footage showing Holloway's approach to the vehicle, the exchange at the driver's window, and the subsequent search. The footage showed Holloway approaching the vehicle with his flashlight, asking for license and registration, and then asking Rook to step out of the car for officer safety. The audio was partially muffled by wind and the sound of passing traffic, but Holloway's voice could be heard asking, "Is there anything illegal in the car?" Rook's response was audible, but ambiguous. "I don't think so." Then, less clearly, a follow-up question from Rook. "Do I have to let you search?" Holloway's reply was indistinct, lost in the ambient noise, but the next frame showed Rook standing off to the side of the road, arms crossed defensively across his chest, as Holloway opened the rear door and began searching the vehicle, moving methodically from the front seats to the rear compartment. The footage also captured, for just a few seconds, a brief pan across the rear of the vehicle as Holloway walked around to the driver's side, and in that brief moment, the right tail light appeared to be functioning normally, glowing red in the dim light of the roadside, casting a faint reflection on the pavement. Slate concluded his direct examination without addressing the discrepancy, either because he had not noticed it or because he hoped the defense would not raise it, and Judge Keystone made a note on his legal pad, underlining it twice. North, seated beside Rook at the defense table, circled 2 lines in his notes, one for the taillight, one for the consent, and waited patiently for his turn. Cross-examination began at 2:35 p.m., and Defense Attorney North stood at the podium with his file open, beginning methodically to dismantle the state's case brick by brick. "Deputy Holloway, your arrest report states that the reason for the stop was a broken tail light, correct?" Holloway confirmed, his voice steady. "And you testified under oath today, just a few minutes ago, that the tail light was broken, correct?" Holloway confirmed again, nodding. North then asked the court to replay the body camera footage, specifically the moment when the camera panned across the rear of the vehicle. Judge Keystone directed the clerk to replay the relevant section, and the courtroom watched in silence as the footage played again, this time frozen at the precise frame showing the illuminated taillight. "Deputy, does that taillight appear to be illuminated and functioning normally?" Holloway shifted uncomfortably in his seat, his confidence visibly wavering. "It might have been intermittent," he said, his voice less certain now. "It might have been working at that moment, but not when I first observed it." North did not press further on that point. Yet. He had planted the seed of doubt, and he knew Judge Keystone had seen it too. Instead, he shifted seamlessly to the consent issue, the heart of the suppression motion. "Deputy, you testified that the defendant gave verbal consent to the search. What exact words did he use?" Holloway paused, his hands gripping the arms of the witness chair. "He said it was okay. He said I could search." North's voice sharpened, cutting through the courtroom. "Did he use the word okay? Did he use the phrase, 'you can search'? What were his exact words?" Holloway hesitated, glancing briefly toward Prosecutor Slate, who remained seated and silent, offering no help. "I understood him to consent based on his body language and the totality of the interaction." North's voice rose slightly, emphasizing each word. "I didn't ask what you understood, Deputy. I asked what words he used. Did he say yes? Did he say okay? Did he say go ahead? Did he use any affirmative word indicating consent?" Holloway looked down at his hands, his voice dropping. "Not exactly those words, but—" Judge Keystone interrupted, his voice calm, but utterly firm, leaving no room for equivocation. "Deputy, answer the question directly and completely. Yes or no? Did the defendant use the word yes, okay, go ahead, or any other affirmative word clearly indicating consent to the search?" The courtroom was silent, the air thick with tension. Holloway exhaled slowly, the weight of the moment settling on his shoulders like a physical burden. "No, Your Honor." The words hung in the air, and the courtroom went utterly still, the silence broken only by the faint hum of the ventilation system. North closed his folder with deliberate, measured precision. "No further questions, Your Honor." Slate stood immediately, his face flushed, and requested a sidebar, which Judge Keystone granted with a curt nod, gesturing both attorneys to approach the bench. At the bench, with the court reporter's stenograph capturing every word for the permanent record, Prosecutor Slate argued urgently that the deputy's testimony was substantively consistent with the arrest report, and that any ambiguity or inconsistency was a matter of interpretation and recollection under stress, not intent to mislead the court or fabricate evidence. He emphasized that consent searches often involve non-verbal cues and implied consent based on the totality of the circumstances, and that the law does not require magic words or explicit verbal consent for a search to be lawful. North countered forcefully that the arrest report explicitly stated verbal consent, yet the deputy had just admitted under oath that no such verbal consent was given, and that this was not a trivial discrepancy or a matter of interpretation. It was the foundation of the state's case for the lawfulness of the search, and if that foundation was false, the entire search was unconstitutional under the Fourth Amendment, and the evidence must be suppressed. Keystone, his expression hardening with each passing moment, asked Slate directly if he wished to recall the witness or introduce additional evidence to clarify the consent issue or explain the inconsistency. Slate declined, calculating that further questioning would only deepen the hole, and requested instead to proceed directly to closing arguments where he could frame the issue more favorably. Keystone denied the request without hesitation, his tone leaving no room for negotiation, and both attorneys returned to their tables. Judge Keystone then turned to face the witness box and asked Holloway directly, on the record, "Deputy, are there any other discrepancies between your arrest report and your recollection of the events that night? Anything else that you wrote in the report that does not accurately reflect what happened?" Holloway, visibly shaken, his hands trembling slightly, said no. Keystone made another note, his pen moving deliberately and slowly across the page, and then announced a 15-minute recess to review his notes, consider the testimony, and determine how to proceed. When the hearing reconvened at 3:15 p.m., the atmosphere in the courtroom had changed palpably. Judge Keystone did not invite closing arguments or ask for further testimony. Instead, he addressed both counsel on the record, his voice measured but grave, carrying the weight of the decision he was about to announce. He stated that he had serious and substantial concerns about the testimony he had just heard, particularly the discrepancy between the arrest report and the deputy's sworn testimony regarding consent, and that he was considering whether to refer the matter to the Granite County District Attorney's Office for review under the state's perjury statute, as well as to the State Bar's Disciplinary Council for potential prosecutorial oversight regarding the state's obligation to disclose exculpatory evidence. Prosecutor Slate stood immediately, his voice tight with frustration and barely controlled anger, and objected strenuously, arguing that no perjury had occurred because the deputy's testimony was a matter of recollection, interpretation, and the stress of testifying, not intentional falsehood or deliberate deception, and that a premature referral would prejudice both the witness and the state's case and could have devastating consequences for Deputy Holloway's career and reputation. Defense Attorney North rose and argued forcefully and passionately that the discrepancy was not trivial, not a matter of interpretation, and not excusable. The arrest report had been used to establish probable cause for the search, had been relied upon by the prosecutor in charging the case, and had been presented to the court as a truthful account of what happened. If that report contained material falsehoods, and the deputy's own testimony proved that it did, then the search was unconstitutional under the Fourth Amendment, and the evidence must be suppressed to deter future violations and preserve the integrity of the judicial process. Keystone listened to both arguments without interruption, his face impassive, and then ruled from the bench with the clarity and precision that had defined his 15 years on the bench. He granted the motion to suppress in its entirety, finding that the state had failed to meet its burden of proving by a preponderance of the evidence that Rook had given voluntary, knowing, and uncoerced consent to the search, and that the deputy's testimony, when combined with the body camera evidence, demonstrated conclusively that no such consent existed. He further found that the initial stop, based on a taillight that appeared in the video to be functioning normally, lacked the reasonable suspicion required under the Fourth Amendment, and that the totality of the circumstances, the pretextual nature of the stop, the ambiguous consent, the coercive roadside environment, suggested the stop was initiated not for a legitimate law enforcement purpose, but as a fishing expedition designed to circumvent constitutional protections. He ordered the physical evidence excluded from any future proceedings, making it inadmissible at trial, and set a status conference for the following week to determine whether the state would proceed with the case or dismiss the charges. Then, without prompting from either counsel and without invitation for argument, Keystone stated clearly and unambiguously that he was ordering a complete transcript of the hearing to be prepared at state expense and forwarded to the district attorney's office and to the State Bar's disciplinary council for independent review, citing his obligation under the state's judicial ethics rules, specifically Canon 3, which requires judges to maintain the integrity and impartiality of the judiciary. 2. Report conduct by attorneys, law enforcement officers, or other participants in the judicial process that seriously calls into question an officer's honesty, trustworthiness, or fitness to serve as a witness in future criminal cases. The ruling took less than 12 minutes from start to finish. Prosecutor Slate sat down heavily, his face flushed with a mixture of frustration, embarrassment, and anger. Deputy Holloway, still seated in the gallery after being formally excused from the witness stand, stared at the floor, his career and reputation hanging in the balance. Rook exhaled audibly for the first time in what felt like hours, his shoulders dropping, relief flooding through his body. North remained standing, watchful and cautious, knowing from years of experience that the ruling was only the beginning of a much larger storm that would sweep through the courthouse, the police department, and the legal community. Within 48 hours, the legal machinery of Granite County kicked into high gear, grinding forward with the relentless momentum of a system determined to scrutinize what had happened in Courtroom 4. Prosecutor Slate, after consulting with his supervisors and the elected district attorney, filed a detailed motion for reconsideration, arguing in 20 pages of carefully crafted legal prose that Judge Keystone's decision to refer the matter to disciplinary authorities was premature, unsupported by the evidence, and constituted an inappropriate exercise of judicial power that overstepped the boundaries of the court's role as a neutral arbiter. He further argued that the suppression order was based on an overly restrictive and legally erroneous interpretation of consent law that contradicted decades of established precedent from the state Supreme Court and the federal courts. North opposed the motion with an equally detailed brief outlining the legal basis for the suppression, the factual findings supporting the judge's ruling, and the judge's clear ethical duty under the Judicial Code to report potential misconduct when it comes to light during court proceedings. Keystone denied the motion without a hearing, issuing a brief written order reiterating his concerns about the integrity of the testimony, noting that the referral was not a finding of misconduct or a determination of guilt, but rather a procedural step to ensure accountability and protect the integrity of future cases, and emphasizing that the disciplinary authorities, not the trial court, would make the ultimate determination of whether misconduct occurred. Slate, under pressure from his superiors and facing the political reality that the case against Rook was now fatally wounded, filed a notice of interlocutory appeal, seeking immediate review of the suppression order by the state appellate court before trial. The appeal was granted on an expedited basis, with the appellate court recognizing the importance of the legal issues raised and the potential impact on law enforcement practices throughout the state, and oral argument was scheduled for 6 weeks later at the state capitol. In the interim, the machinery of accountability began to turn. The Granite County District Attorney's Office, responding to Judge Keystone's referral and facing mounting public pressure from defense attorneys and civil liberties groups, opened an internal review of Deputy Holloway's conduct, assigning 2 senior prosecutors to examine not only this case, but also Holloway's prior arrests, reports, and testimony to determine if a pattern of misrepresentation or exaggeration existed. The Harbor Police Department, facing potential liability and reputational damage, placed Holloway on paid administrative leave pending the outcome of the investigation, a move that was reported in the local newspaper and quickly became the subject of intense speculation and debate in the legal community. The State Bar's Disciplinary Council, acting independently, opened a preliminary inquiry into whether Prosecutor Slate had violated his duties under the state's rules of professional conduct, specifically the rules requiring prosecutors to disclose exculpatory evidence to the defense and to ensure that witnesses provide truthful testimony. Slate vigorously denied any misconduct, arguing in a detailed written response that he had relied on the arrest report in good faith, that he had not been aware of the inconsistencies between the report and the video until they emerged during North's cross-examination, and that he had acted appropriately and ethically throughout the case. The inquiry remained open, and Slate's name began circulating in local legal circles, not as a target of formal discipline or criminal investigation, but as a cautionary example of the professional and reputational risks of relying on police reports without independent verification and careful review of all available evidence. For Rook, the immediate consequence was profound and overwhelming relief. The charges were stayed pending the outcome of the appeal, and he was released from all conditions of pretrial supervision, free to return to his job, his family, and his life, while the legal system sorted out the tangled mess that his case had become. For Deputy Holloway, the consequences were mounting with each passing day, the weight of the referral and the investigation pressing down on him like a physical burden. The Internal Affairs investigation, conducted over 6 weeks with interviews, document review, and analysis of prior cases, found that his arrest report had contained material inaccuracies regarding both the taillight and the consent, that his testimony had failed to correct those inaccuracies promptly and clearly when given the opportunity, and that his conduct, while perhaps not rising to the level of intentional perjury, demonstrated a troubling pattern of exaggeration and overstatement that undermined his credibility and fitness to serve as a law enforcement officer. The investigation recommended a formal written reprimand, mandatory retraining on report writing standards and the legal requirements for consent searches, and a probationary period during which all of his reports would be subject to supervisory review. 3 months after the suppression hearing, the state appellate court issued its opinion, a 30-page detailed and carefully reasoned decision that would be cited in courtrooms across the state for years to come. The court upheld Judge Keystone's suppression order in its entirety, finding no abuse of discretion in his factual findings or legal conclusions, and specifically praised his decision to refer the matter to disciplinary authorities as an appropriate exercise of judicial responsibility. The opinion, written by a senior appellate judge with decades of experience, noted that trial judges have broad discretion to exclude evidence when the state's case is built on foundations that crack under scrutiny, and that the exclusionary rule exists not primarily to punish police officers, but to deter constitutional violations and to ensure that the government does not benefit from searches and seizures that violate the Fourth Amendment's guarantee against unreasonable searches. The court emphasized that the judiciary's duty to safeguard the integrity of the criminal justice system includes the responsibility to report and address conduct that undermines public trust and confidence, and that Judge Keystone had acted properly and courageously in fulfilling that duty. With the appellate court's affirmance, the legal path forward became clear. The case against Rook was dismissed with prejudice, meaning it could not be refiled or recharged under any circumstances, and Rook's record was cleared. The State Bar's inquiry into Prosecutor Slate ultimately closed 6 months later, without formal charges or public discipline, the Disciplinary Council finding that while Slate's preparation could have been more thorough, there was insufficient evidence of intentional misconduct or ethical violations warranting formal proceedings. But the damage to Slate's reputation was done, and the strain of the case, the scrutiny, the second-guessing, the whispered conversations that stopped when he entered a room, took its toll. He left the district attorney's office a year after the hearing, citing personal reasons and a desire to pursue opportunities in private practice, though everyone in the courthouse understood the real reason. Deputy Holloway, facing the completed internal affairs report and the impossibility of rebuilding his credibility, resigned from the Harbor Police Department 6 months after the investigation concluded, his departure noted in a brief press release that mentioned his years of service, but carefully avoided any reference to the reasons for his resignation. His name appeared on a list quietly maintained and shared by defense attorneys throughout Granite County, a list of officers whose credibility had been impeached in prior testimony, whose reports and statements would be subject to heightened scrutiny, and whose presence as a witness in a criminal case would trigger immediate and aggressive cross-examination. The aftermath of the case extended well beyond the individuals directly involved, reshaping policies, practices, and assumptions throughout the criminal justice system in Granite County. The district attorney, facing pressure from defense attorneys, civil liberties advocates, and editorial writers at the local newspaper, announced a comprehensive new policy requiring prosecutors to personally review all body camera footage and other recorded evidence before filing charges in cases involving consent searches, warrantless searches, or stops based on minor traffic violations, and to disclose immediately to defense counsel any discrepancies, inconsistencies, or gaps between written reports and recorded evidence. The policy, formalized in a written directive distributed to all prosecutors in the office, emphasized that the prosecutor's duty is not merely to win cases, but to seek justice, and that justice requires full transparency and candor about the strengths and weaknesses of the evidence. The Harbor Police Department, stung by the public criticism and facing potential civil liability from other defendants whose cases might be challenged based on Holloway's discredited testimony, revised its training protocols for officers at all levels, emphasizing the critical distinction between implied consent and verbal consent, the legal and professional risks of overstating or embellishing facts in arrest reports, and the importance of ensuring that written reports match precisely what is captured on body camera footage. The training included specific case studies drawn from the Rook case, with instructors walking officers through the cross-examination, the ruling, and the consequences, making clear that credibility is a police officer's most valuable professional asset, and that once lost, it cannot be recovered. Judge Keystone, recognizing the broader implications of the case, issued a detailed written order explaining his reasoning, which was published in the state's judicial newsletter, posted on the court's website, and quickly became required reading in law schools, judicial training programs, and continuing legal education seminars across the state. The order, praised by legal scholars and cited in subsequent cases, noted that the power to refer potential misconduct to disciplinary authorities is not punitive or vindictive, but protective and systemic, designed to ensure that the legal system's gatekeepers, judges, prosecutors, and law enforcement are held to standards that maintain public trust and confidence in the fairness and integrity of the process. Defense attorney North, suddenly in demand as a speaker and trainer, used the case extensively in his teaching, conducting seminars for public defenders and private criminal defense attorneys on motion practice, cross-examination techniques, and the immense strategic value of body camera evidence in exposing weaknesses, inconsistencies, and fabrications in police testimony. His seminars, attended by hundreds of lawyers from across the state, emphasized that the Rook case was not an aberration, but a template, a roadmap for how careful preparation, strategic questioning, and relentless focus on the details can expose the truth and protect constitutional rights, even when the odds seem insurmountable. The case became a reference point, a touchstone, a cautionary tale invoked in courthouse hallways, law school classrooms, and police academy training rooms, whenever anyone needed to illustrate the devastating cost of a single misstatement on the stand and the far-reaching ripple effects that follow when the truth is not told clearly, completely, and consistently from the very beginning. The lesson of the case was not abstract or theoretical. It was visceral, immediate, and impossible to ignore. It was visible in the empty witness box on the afternoon after the hearing, when the court clerk methodically reset the room for the next case and the gallery slowly emptied, leaving behind only the lingering sense that something fundamental had shifted in the relationship between the courts, the police, and the prosecutors. It was visible in the growing stack of motions and briefs that accumulated on Judge Keystone's desk in the months that followed, each one citing his order as precedent for suppressing evidence, for scrutinizing police testimony with greater rigor and skepticism, or for demanding that prosecutors disclose inconsistencies before trial rather than waiting for them to emerge during cross-examination. It was visible in the way Prosecutor Slate now reviewed every single body camera file before approving any charging decision, triple-checking every detail, comparing timestamps, and insisting that officers clarify any ambiguity or inconsistency before the case moved forward. It was visible in the way Deputy Holloway's replacement at Harbor PD was trained to write reports that matched the video with absolute precision, word for word, moment for moment, frame by frame, because the margin for error had shrunk to zero, and the consequences of carelessness, exaggeration, or fabrication had become devastatingly and undeniably clear. The case had promised a routine suppression hearing, a simple procedural motion that would be resolved in an afternoon and forgotten by the end of the week, just another case number in the endless stream of criminal matters flowing through the courthouse. But it delivered something far more consequential and enduring, a public reminder that the courtroom is not a place where approximations and assumptions are acceptable, that every word spoken under oath carries weight that extends far beyond the immediate case, and that the system depends utterly and absolutely on the accuracy and integrity of those words. When that accuracy fails, when that integrity is compromised by carelessness or calculation or the simple human tendency to shade the truth in ways that seem minor at the time, the system responds, not with leniency or understanding or second chances, but with the full force of its procedural and ethical mechanisms designed over centuries of common law tradition to protect the innocent, hold the powerful accountable, and preserve the fragile trust that makes justice possible in a democratic, Society. The paradox at the heart of the case was elegantly simple, almost mathematical in its clarity. Deputy Holloway believed his testimony was close enough to the truth, that the small discrepancies between his report and the reality captured on video didn't really matter in the grand scheme of things, that no one would notice or care about the gap between verbal consent and silence. Judge Keystone proved, with ruthless clarity and unwavering commitment to principle, that in a courtroom governed by rules and oaths and the sacred duty to tell the truth, close enough is never, ever enough. The gavel fell, the record was sealed, the case was officially closed, but the consequences, measured in shattered careers, revised policies, new training protocols, and legal precedents that would shape cases and influence judicial decisions for years to come, continued to reverberate through the halls of Atlas Hall and beyond, touching every corner of the criminal justice system in Granite County and serving as a permanent reminder that truth matters, that credibility matters, and that the cost of losing both is higher than anyone wants to pay. In the weeks and months after the appellate court's decisive opinion, affirming the suppression and praising Judge Keystone's handling of the case, the story continued to unfold in ways both expected and surprising, touching lives and careers far removed from courtroom 4. Defense attorney North received a steady stream of letters, emails, and phone calls from colleagues in neighboring counties and even other states, all requesting copies of the suppression hearing transcript, the appellate opinion, and his cross-examination outline, to use in similar cases where police testimony and body camera evidence diverged in ways that raised questions about credibility and truthfulness. North sent the materials generously, along with brief covering notes emphasizing the key strategic moments. The decision to let the officer commit to his story on direct examination before introducing the contradictory evidence, the careful framing of questions to eliminate wiggle room, the judge's intervention at the critical moment, the officer's devastating admission, and the systemic consequences that followed from that single moment of truth. Judge Keystone, when asked by a law student interning at the courthouse during the summer session why he had gone so far as to refer the matter to disciplinary authorities rather than simply ruling on the motion and moving on to the next case, responded by pointing to the framed copy of the Judicial Ethics Code hanging on the wall of his chambers, specifically Canon 3, which requires judges to take appropriate action when they become aware of conduct by lawyers, law enforcement officers, or other participants in the legal process that undermines the administration of justice and erodes public confidence in the courts. He said quietly but with absolute conviction, "If I see misconduct and I do nothing, if I look the other way because it's uncomfortable or politically inconvenient or because I don't want to make waves, then I become complicit in the corruption of the system I swore an oath to uphold and protect. That's not what the oath allows. That's not what justice requires. That's not why I became a judge." Prosecutor Slate, interviewed months later for a lengthy article in the State Bar Journal on discovery obligations and the evolving duties of prosecutors in the digital age of body cameras and social media, acknowledged candidly that the case had fundamentally and permanently changed the way he prepared for hearings and trials, forcing him to question assumptions he had never examined before, to verify facts he had always taken on faith, and to recognize that his duty to seek justice sometimes conflicts with the natural human desire to win. But he declined to discuss the case in detail or to name names, citing ongoing professional considerations, personal privacy, and a sincere desire to move forward rather than dwell on the painful past. Rook, the defendant whose case had triggered the extraordinary chain of events that reshaped practices and policies throughout Granite County, returned quietly to his life outside the criminal justice system, his record clear, his freedom restored, his future no longer overshadowed by the threat of years in prison. But the experience had left him profoundly and permanently wary of the machinery of justice, skeptical of the claim that the system always corrects itself, and deeply uncertain about whether what happened to him was justice finally working as designed or just a lucky break, a rare moment of clarity and courage in a system that usually operates in shadow, ambiguity, and institutional inertia. In a brief conversation with North in the courthouse parking lot after the final dismissal order was entered, Rook asked the question that haunted him late at night when he couldn't sleep. So the deputy lied on the stand. The judge caught him. My case got thrown out, and everyone says the system worked. But did the deputy ever get charged with perjury? Did he face any real consequences? North paused before responding, choosing his words with the care of a lawyer who understands that the truth is often more complicated and less satisfying than we want it to be. He shook his head slowly and explained that referrals for criminal investigation rarely result in actual prosecution, especially when the alleged falsehood is embedded in nuance, interpretation, and the subjective assessment of consent rather than an outright provable black-and-white fabrication of easily verifiable facts. Rook shook his head in frustration and disbelief, his voice rising slightly. So he just walks away. He lies under oath, ruins my life for months, puts me through hell, and nothing really happens to him, except he loses his job. North paused again, then responded carefully and honestly. Not entirely. His career in law enforcement is effectively over. He'll never work as a police officer again anywhere in this state. His credibility is permanently destroyed. Every case he touched, every arrest he made, every report he filed is now subject to challenge, scrutiny, and potential reversal. Defense attorneys across the county and beyond have his name on a list that gets shared and updated. He'll never testify in a courtroom again without that impeachment hanging over him like a dark cloud. His reputation is ruined. That's not nothing. It's not criminal charges and it's not jail time, but it's not nothing. Rook nodded slowly, processing the answer. But the look on his face, a mixture of resignation, lingering anger, and profound disillusionment, said clearly that he remained unconvinced, still grappling with the vast and frustrating gap between what he had hoped justice would look like and what it actually delivered in the messy, imperfect real world. The final image of the case, the image that captures its essence and its enduring meaning, is not dramatic or cinematic. It is quiet, contemplative, almost mundane in its ordinariness, yet somehow profoundly moving in its simplicity. It is a courtroom in Atlas Hall, late on a Thursday afternoon in early autumn, empty except for Judge Keystone sitting alone at the bench, reviewing motions and orders for the next day's crowded calendar. The overhead fluorescent lights hum softly in the silence, and the air is still and heavy with the accumulated weight of 1,000 cases argued, decided, appealed, and resolved in this space over the decades. On the bench in front of him, marked with yellow, sticky notes and annotated in the margins with his careful handwriting, lies the transcript of the suppression hearing, its pages flagged at the passages he has returned to again and again in the months since the ruling. Holloway's evasive answers that grew progressively less convincing, North's pointed and relentless questions that eliminated every avenue of escape, Slate's failed objection that exposed the weakness of the state's position, and the pivotal, unforgettable moment when the truth finally broke through the layers of obfuscation, rationalization, and denial. Keystone reads the passages one more time, slowly and carefully, not because he doubts his ruling or second-guesses his decision to refer the matter to disciplinary authorities, but because he understands in his bones that rulings like this are rare, precious, and fragile, and that they matter in ways that extend far beyond the docket number, the parties' names, and the immediate outcome of the case. The courtroom is a sacred space where power and truth intersect, collide, and ultimately determine outcomes that shape individual lives. define the boundaries of acceptable conduct, and test whether a society will hold those who wield authority accountable to the same standards it imposes on everyone else. When those two fundamental forces, institutional power and individual truth, come into direct and unavoidable conflict, the outcome is never certain, never guaranteed, never inevitable until the gavel falls and the words are spoken that cannot be taken back or softened or explained away. In this case, against considerable odds and despite significant resistance from those with much to lose, the truth won. Not because truth always wins, it doesn't, but because the procedural rules of evidence, the ethical obligations binding officers and counsel, the courage of one defense attorney who prepared thoroughly and questioned relentlessly, and the judicial duty to protect the integrity of the process all converged at precisely the right moment, in precisely the right way, with precisely the right judge on the bench, producing the right outcome and sending the right message. The case is closed now, officially and finally, the appeals exhausted, the motions denied, the record sealed and filed away in the courthouse archives. But the questions it raised, searching, uncomfortable, essential questions about how much trust we place in the word of those who wear badges and carry guns, about what happens when that trust is betrayed or even just carelessly damaged, about whether the system can truly repair itself when misconduct is exposed to the harsh light of public scrutiny, and about whether justice delayed or justice denied or justice delivered only through extraordinary effort and luck is really justice at all. Those questions remain open, unresolved, contested, waiting for the next case, the next hearing, the next moment, when someone stands in a witness box with their hand raised and their voice steady and has to decide in real time, under pressure, with careers and reputations and freedom hanging in the balance, whether to tell the truth, the whole truth, and nothing but the truth, or to offer something close to it, something almost true, something plausible enough and defensible enough to pass without. Serious challenge in a system where most cases never go to trial and most testimony is never seriously tested. If you want to see how these critical moments of truth, accountability, and institutional reckoning unfold in real courtrooms with real human stakes and real consequences that extend far beyond the parties directly involved, subscribe to this channel and join a growing community of people who care deeply about justice, transparency, fairness, and the rule of law. And if you've ever witnessed, experienced, or been touched by a case where a single lie, a single moment of dishonesty or evasion or convenient memory failure changed everything and sent lives spiraling in directions no one anticipated or intended, share your story in the comments below, because this story, like every courtroom story worth telling and remembering, is never really over. The truth has a way of echoing forward through time, shaping not just the immediate case, but the cases that follow, the policies that evolve in response, the training that changes to prevent repetition, the standards that rise or fall depending on whether we have the courage to enforce them, and the fragile, essential, irreplaceable trust that holds the entire system together and makes the possibility of justice, imperfect, delayed, hard-won, but real, something more than just empty words. The gavel has fallen, the transcript is filed, the courthouse has moved on to the next case and the next crisis, but the work of justice, messy, imperfect, frustrating, vital, and never truly finished, continues every day in courtrooms across this country, one case at a time, one truth at a time, one hard decision at a time.